This is True Legal Cases Explained Simply with Sankofa. Episode 1. The Man Who Went Back for His Hat. Based on a landmark 2024 Australian Federal Court defamation ruling. There is an old proverb. When the lion finally releases you from its jaws, you do not go back inside the den. But some men do not listen to old proverbs. This is the story of a man we will call the staffer. A man who escaped criminal trial by the skin of his teeth and then went back for his hat. To understand this case, we must go back to the year 2019, the seat of government, Canberra, Australia, the most powerful building in the country, the place where laws are made. Inside that building, late at night, something happened. Something that a young woman, we will call her the witness, would carry with her for years. The witness was a political staffer, young, ambitious, working for a senior government minister. Her colleague was the staffer. According to the witness, after a night out, the staffer brought her back to the government building, to the private ministerial office of a cabinet minister. And there, she says, he raped her. She was, by her account, drunk, semi-conscious, unable to consent. When she woke up, he was gone. The next morning, cleaners found evidence that someone had been in that office. But for a long time, nothing happened. The powerful wheels of bureaucracy turned slowly. Complaints were made, then withdrawn. The story went quiet until 2021. February 2021. A major Australian television network broadcast an interview. A well-known journalist sitting across from the witness. The story of what allegedly happened inside that government building was now on national television. The journalist did not name the staffer directly, but those who knew the story knew exactly who she was talking about. The broadcast painted a picture of a woman whose great complaint had been mishandled, silenced, buried under political convenience. Australia watched. Australia talked. Australia was angry. And somewhere, the staffer was watching too. And he was furious. Because in Australia, if someone broadcasts something that damages your reputation, even without naming you, you may have a case for defamation. The staffer believed he had been clearly identifiable in that broadcast. He believed his reputation had been destroyed. And he decided he would fight back. He would sue the television network. He would sue the journalist. He would go to court and make them pay. But wait, before we reach the defamation case, we must talk about the criminal trial. Because this story has layers, like an onion, and each layer has a sting. In 2022, the staffer faced criminal charges for the alleged rape of the witness, a proper criminal trial in the courts of the Australian Capital Territory. Now, in a criminal case, the standard is very high. The prosecution must prove guilt beyond reasonable doubt. No other reasonable explanation, no shadow of doubt. But the trial did not finish. A juror was found to have conducted their own research, bringing outside materials into the deliberation room. This is a serious breach of court rules. The judge declared a mistrial. The trial collapsed. And the charges? They were eventually dropped. Not because the staffer was found innocent, but because there were concerns about the well-being of the witness, about whether putting her through another trial was safe or fair. The staffer walked free, without a conviction, without a verdict, a free man. And here, my friend, is where wisdom should have spoken to him. He had escaped the lion's den. But wisdom was not listening that day.
In 2023, the staffer launched defamation proceedings against the television network against the journalist. Now, here is what you must understand about defamation law in Australia. When you sue for defamation, you are essentially saying, what was said about me was false, and it damaged my reputation. The defendant, in this case the network, can fight back with what is called a truth defense. And here is the dangerous part. If the network could prove in the civil court that what was broadcast was true, then the staffer would not only lose his case, he would walk out of that courtroom with the judge having made findings about his conduct. Findings that the whole world would read. His lawyers warned him. The risks were extraordinary, but the staffer pressed forward. The case went to the Federal Court of Australia, before a senior federal court judge, one of Australia's most respected and sharp-tongued judicial minds. And the trial was not kind to the staffer. In April 2024, the judge delivered his verdict. It ran to over 1,000 paragraphs. 1,000 paragraphs. It was thorough, devastating, historic. The judge found on the balance of probabilities, the civil standard, that the staffer had graped the witness. This was not a criminal conviction, but in the world of civil law, the scales had tipped. The judge concluded that the two had engaged in bed matters, that the witness, in her inebriated and semi-conscious state, had not consented. And then the judge described the staffer in 4 words. 4 words I want you to hear slowly. A, persistent, self-interested, liar. He said the staffer had told deliberate lies, organized, calculating, strategic lies. The network's truth defense was upheld. The staffer lost. Not only did he lose, he was ordered to pay the legal costs of the network and the journalist. The trial is estimated to have cost between 8 and 10 million Australian dollars. And the staffer, he is on government welfare benefits with no money to pay. The man who went back for his hat left the courtroom with no hat, no coat, and no reputation left to protect. Now, what does this case teach us? About law, about life, about the choices we make when we are angry. First, defamation law is a double-edged sword. When you sue for defamation, you invite the other side to prove the truth. If you are hiding something, the courtroom will find it.
Second, civil courts and criminal courts are different animals. A criminal trial requires proof beyond reasonable doubt. A civil trial requires only the balance of probabilities, meaning more likely than not. The staffer may have escaped criminal conviction, but he could not escape the lower civil threshold. Third, the truth defense is powerful. If a media organization can prove what it broadcast was true, it will not be liable for defamation. This is a cornerstone of press freedom. And fourth, listen to me carefully on this one. The judge's final words said everything. In his closing paragraphs, he reached back to an older case. A man who had sued a newspaper and lost, despite the newspaper having written true things about him. In that case, the judge said the plaintiff had left court with his reputation. In this case, our judge applied those same words to the staffer, and then he added his own. He said, having escaped the lion's den, the man made the mistake of going back for his hat. My friend, when life releases you from the jaws of consequence, walk away, and do not look back. This was episode 1 of Sankofa Court. True legal cases explained simply. This case continues. An appeal was filed. A separate allegation has emerged in another part of the country. This story is not over, but today
You understand the foundation. You understand defamation law. You understand the balance of probabilities. And you understand what it means to go back for your hat. If this story moved you, if justice matters to you, subscribe. Share it with someone who needs to hear it. And leave your thoughts below. Because the law does not sleep. And neither does the truth. Until next time.